Hello and welcome back to the channel. Today we are diving deep into developing story from South Sudan that raises serious questions about justice, evidence, and political motives. We are talking about the ongoing treason trial against 8 high-profile defendants, including suspended First Vice President Dr. Riek Machar and suspended Petroleum Minister Puot Kang Chuol. Over the past 2 weeks, explosive testimony and evidence have been presented in court, but as we dig deeper, the quality of this investigation reveals troubling flaws that could undermine the entire case. Let's break it down. First, let me bring you up to speed on what happened. In March 2025, a military garrison in Nasir, Upper Nile State, was attacked. According to officials' reports, 256 soldiers from the South Sudan People's Defense Force were killed. Now, 8 people are on trial facing extremely serious danger: treason, crimes against humanity, mass murder, terrorism, and destruction of property. The most prominent defendants are Riek Machar, the suspended First Vice President, and Puot Kang Chuol, the suspended Petroleum Minister. This trial has been going since September 22, 2025, and we are now looking at testimony from multiple sessions that reveals a deeply problematic investigation. On Friday, October 17th, during the 11th session, Major General Basilo Thomas Wani, a police commissioner from Northern Barghazal State, testified as the lead investigator. His testimony focused primarily on Puot Kang Chuol, who is listed as the first defendant. Here's what Wani claimed. Puot Kang allegedly sent $30,000 by plane to fund the White Army militia's attack on Nasir. The money was supposedly sent in 2 installments. The first one was described a smaller amount as a ritual. The second payment was the bulk amount, $30,000, which was then distributed among 15 Payams administrative districts, with each receiving $2,000. According to Wani's testimony, one chief in Payam refused the money, saying he wouldn't mobilize young people to attack the military garrison or the army garrison. That chief was then reportedly forced to surrender his position to the Nasir County Commissioner, James Galwalo, who is a member of Machar's SPLM-IO movement. The investigator also claimed that Puot Kang was in direct contact with attackers via WhatsApp, receiving intelligence reports, casualty lists, and battle updates in real time. He allegedly even sent money to purchase weapons and ammunition and made false statements to United Nations on Radio Maria. Then on Monday, October 17th, the prosecution presented additional evidence. Most significantly, they presented what they call digital forensics evidence, a report prepared in South Africa analyzing seized laptops and mobile phones belonging to the accused. This report, dated August 26, 2025, contains 15 attachments and was submitted under seal. The prosecution claims this evidence will link the accused to communication and around the Nasir incident. The defense team, led by Dr. Gary Raimondo Lege and Anis Tombe Agustino, immediately raised objections, citing violations of South Sudan's constitution, improper chain of custody, and questions about the diplomatic legality of cooperation with South Africa. The presiding judge, James Alala Deng, declined to immediately admit the digital forensics report, stating it must be authenticated by the person who prepared it. He also refused to mark videos and audio evidence until they are played in court. Now, here's a critical detail. This trial is being conducted in closed session. That means no public observation, no media presence in the courtroom, and information flows through only one control channel. Now, let's analyze what's really going on here. I have identified 10 major problems with this investigation that should concern anyone who cares about justice and the rule of law. The entire case against Puot Kang, at least as presented on October 17th, rests on the testimony of one man, Major General Basilo Thomas Wani. But here's the problem. Wani doesn't claim to have witnessed any of these events firsthand. Where are the bank records? Where are the flight manifests? Where are the telecommunication records? Where are the witnesses who saw money firsthand? In any serious criminal investigation, especially one involving charge as grave as treason and crimes against humanity, you need corroborating evidence. You can't convict someone based solely on what one investigator says happened, especially when that investigator wasn't even there. Under South Sudan's Criminal Procedure Act and International Fair Trial Standards, this kind of uncorroborated testimony should not be sufficient for conviction. Yet, this is what we are seeing as the foundation of the case. Now let's talk about this alleged money transfer. The investigator says $30,000 was sent by plane, but that's incredibly vague. Which plane? What airport did it depart from? What airport did it land at? Who was the pilot? Who received the money on the other hand? And where are these witnesses? In any legitimate investigation, especially in a case of this magnitude, you would have a complete paper trail. Flight logs, passenger manifest, airport security footage, banking withdrawal records showing where the money came from, witnesses' testimony from airport staff or the people who handled the cash. We have none of that, just a claim that money was sent by plane. This isn't evidence, this is a story without proof. In high-profile terrorism and treason cases around the world, financial tracking is absolutely crucial. Prosecutors use forensic accountants, banking records, transaction logs, everything they can get their hands on. The absence of any financial documentation here is staggering. Now we come to perhaps the most damning problem with this entire case, the handling of digital evidence. Here's what we know so far. The defendants were arrested in March 2025, right after the attack. Their phones and laptops were seized at that time. They were then held in detention from March until September when the trial began. That's 6 full months. During those 6 months, their electronic devices were in the exclusive custody and control of the prosecution. The prosecution then sent these devices to South Africa for forensics examination, and on August 26, 2025, they received a forensic report. Now, the prosecution presented this digital forensic report to the court, and on Monday, October 17, they claimed it contains evidence linking the defendants to the attack, including WhatsApp communication, intelligence reports, and planning documents. But here's the problem. The South African forensic experts who prepared this report has not appeared in court. The prosecution says they will call this expert to testify in those last sessions, but as of now, that hasn't happened. And the judge, to his credit, refused to admit the digital evidence until the forensics examiner testifies in person to authenticate it. Do you see the massive problem here? This is a catastrophic claim of custody issue. In proper digital forensics, chain of custody is everything. From the moment a device is seized, there must be a documented, unbroken, independently verified record of who had access to it, when and what they did with it. This is to prevent tampering, alteration, or fabrication of evidence. But we have a 6-month gap where the prosecution had exclusive control of these devices before they were sent to South Africa. 6 months is an eternity in digital forensics. In that time, anything could happen. Message could have been altered, data could have been planted, evidence could have been fabricated. Think about it practically. If you have someone's phone for 6 months and you have technical expertise or access to technical experts, you could potentially create any digital trail you want. You could add messages, delete messages, modify timestamps, and plant, document anything. And critically, the one person who could testify about the integrity of the forensic examination, the South African forensic experts, hasn't appeared in court yet. This expert is supposed to authenticate the findings, explain the methodology, and confirm that the devices weren't tampered with before reaching South Africa. Without that expert testimony, there is no way to verify that the digital evidence is authentic and untampered. Without proper chain of custody, documentation showing exactly who had access to these devices during those 6 months, there is no way to prove they weren't manipulated. The defense has also raised serious questions about the diplomatic procedures used to send evidence to South Africa. They argue that the correspondence didn't go through proper official channels and that the South African embassy in Juba never formally acknowledged the cooperation. If the legal process for transferring evidence internationally wasn't followed correctly, that's another ground for excluding this evidence entirely. In legitimate courts around the world, this kind of evidentiary gap would be absolutely devastating to the prosecution. You cannot convict someone based on evidence from devices that were in your exclusive control for 6 months without rigorous independent verification of their integrity. Now listen carefully to the structure of the investigator's testimony from October 17. He talks about what a chief said, what a commissioner did, what the attackers reported. But where are these people? Why aren't they in court testifying? This is classic hearsay, second-hand information that cannot be cross-examined. In a fair trial, you have the right to confront your accusers. You have the right to cross-examine witnesses against you. If a chief refused money and was forced to give up his position, that chief should be in court telling his story. If a commissioner collected money, that commissioner should testify. If attackers sent reports, those individuals should be identified and questioned. Without the actual witnesses, we are just hearing stories about stories. That's not evidence that meets international standard. The prosecution did present some documentary evidence on Monday, including death certificates and military reports. But the key allegation about funding and communication still rely on hearsay testimony that hasn't been properly submitted. The defense team made a critical objection that we need to take seriously. They argue that the prosecution violated Article 22 of South Sudan's constitution, which protects the privacy of every person and their correspondence, communication, and property. They also cited violations of the 2008 Criminal Procedure Act, which established clear rules about how evidence must be gathered. Here's the fundamental question. When these phones and laptops were seized, was there a warrant? Did a judge review the request and find probable cause? Was proper legal procedure followed? If WhatsApp messages, phone calls, and communications were extracted from this device. That's a search of private communications under South Sudan's constitution that requires judicial authorization. So the prosecution claims they follow proper chain of custody procedures, using diplomatic bags to transfer evidence to South Africa. But the defense argues that the diplomatic correspondence wasn't handled correctly and that the South African embassy never formally acknowledged the cooperation. If the legal process for seizing, searching, and transferring this evidence wasn't followed correctly, then this evidence was obtained illegally. And in a functioning legal system, illegally obtained evidence is excluded from any trial. The fact that the judge refused to immediately admit the digital forensics report suggests he has concern about the issues. He wants the forensics expert to appear and authenticate the evidence before it's admitted. That's the right approach, but it also highlights how problematic this evidence is. Now, we come to a fundamental legal problem that undermines the entire investigation. The lead investigator, Major General Basilo Thomas Wani, is the police commissioner of Northern Barghazal State. Here's the critical issue. The attack happened in Nasir, which is in Upper Nile State. These are two separately different states in South Sudan, separated by significant distances. Under South Sudan's legal framework, state police commissioners have authority only within their own state boundaries. Wani, as the commissioner of Northern Barghazal, has no jurisdiction authority to conduct criminal investigations in Upper Nile State. That's simply not just his territory, not his jurisdiction, not his legal authority. Think about this in practical terms. Imagine if the police chief of California showed up in Texas to investigate a crime there without any formal authorization from Texas authorities or the federal government. That investigation would be immediately challenged as illegitimate. So, why is a commissioner from Bahr el Ghazal presenting evidence about crimes that allegedly occurred in Nasir? Where are the investigators from Upper Nile State? Where are the local police who would have jurisdiction? Where are the national level authorities who would typically handle crimes of this magnitude? This isn't just technicality. Jurisdiction is a foundational principle of law. Evidence gathered by someone without legal authority to investigate can be challenged and potentially excluded from trial. Every arrest, every search, every interview conducted by Wani in Upper Nile State could be legally invalid. The prosecution has not explained how Wani obtained jurisdiction to investigate this case or what legal authority authorized him to operate outside his state. This alone could invalidate significant portion of the evidence. Let's do some basic math here and logic. The prosecution claims $30,000 was divided among 15 firearms, with each receiving $2,000. Now, think about what we are told this money was supposed to accomplish. It allegedly funded a major military operation that involved the White Army militia and somehow SPLM-IO forces, resulted in the death of 256 soldiers and required arms, ammunition, logistics, and mobilization. So, does $2,000 per firearm sound like enough money to fund that kind of operation? For context, that's about what it might cost to buy a few rifles on the black market, and certainly not enough to fund a coordinated military assault that killed hundreds. According to the military administrative reports presented on Monday, the attack destroyed significant weapon and equipment. The prosecution claims Puot Kang also sent money to purchase arms and ammunition. Where's the evidence of those larger financial transactions? This strains credibility. Either the amount is wrong, the story is incomplete, or something else entirely was happening. The prosecution hasn't explained how such a relatively modest sum could have funded such a devastating attack. The investigator claims Puot Kang made false statements on United Nations on Radio Mariah about troop movements, but this accusation is legally and factually problematic. First, making a statement on the radio, even false story or false one, is not the same as funding or organizing an attack. It's a speech act. Unless the prosecution can prove that these statements were part of a coordinated plan to deceive and facilitate violence, they are irrelevant to charges of treason and terrorism, at least. So second, who determines what a false statement in the context of an armed conflict where information is contested? So the military administrative report presented on Monday includes a March 1st, 2025 letter from Machar and a press statement from SPLM-IO spokesperson Paul Maidang about forced replacements in Nasir. These are political communication from the opposition. So, is the government simply declaring that any statement from the opposition contradicting its narrative is false and criminal? This looks like an attempt to criminalize political speech and opposition viewpoints, which is deeply concerning in any democracy. We need to talk about the elephant in the room, the political dimension of this trial. The defendants include Riek Machar, the leader of the SPLM-IO opposition movement, and several of his associates. The government alleged this was an opposition-led attack. Now, it's certainly possible that opposition figures committed crimes, but the quality of evidence matters even more in politically charged cases, because there's a risk that criminal prosecution is being used as a tool to eliminate political opponent. Look at what we've seen: vague allegations, uncorroborated testimony, missing evidence, constitutional violation, problematic chain of custody for digital evidence. When a government prosecutes its political opposition on such weak evidentiary foundation, it raises serious questions about whether this is legitimate justice or political persecution. And critically, this trial is being conducted in closed session. No public observation, no media presence in the courtroom, and no independent monitors. Information flows through only one control channel, that is the official government source, SSBC. When trials happen behind closed doors, there is no public accountability. No journalism can observe the proceedings. No human rights organization can monitor whether fair trial standards are being met. No independent legal expert can assess the quality of evidence. This is the opposite of transparent justice, which they once promised. In democratic societies, trials are public, specifically because sunlight is the best disinfectant. When the government can prosecute its opponents in secret, using evidence that cannot be independently verified, the potential for the abuse is enormous. So the fact that this trial is closed makes all of the evidentiary problems we have discussed even more concerning, because there is no independent check on what's happening. Perhaps most fundamentally, the prosecution has not established a direct link between the defendant and common responsibility for the attack. Even if we accept all the allegations at face value, receiving reports after the fact does not prove you planned or directed the attack. It doesn't establish command responsibility. It doesn't prove intent. To convict someone of treason, terrorism, or crimes against humanity, you need to prove they played a specific role in planning, ordering, or executing the crime. You need to show intent and action. The military administrative report presented on Monday shows that Colonel Tor Gilathwan, identified as a White Army commander, led the first attack on March 3rd, and the second attack on March 4th involved a combination of White Army and SPLM-IO soldier, blah blah blah. But where's the evidence connecting the defendants in custody to those commanders? Where are the communications ordering the attack? Where are the planning documents? Where are the witnesses who can testify that Machar or Puot Kang Chuol gave instruction to these commanders? Without direct connection establishing command responsibility, this case falls apart legally. So where does this leave us? We have a high-profile treason trial against political opposition figures. The evidence presented includes uncorroborated testimony from a single investigator who lacks jurisdiction, vague allegations about money transfer with no proper trail, digital evidence with a catastrophic 6-month gap in chain of custody, and no forensics expert testimony yet. Hearsay statement from people who aren't in court, and logical inconsistencies that undermine the prosecution's narrative. The investigation appears to violate South Sudan's own constitution and criminal procedural laws. So the trial is being conducted in secret. The judge himself is reluctant to admit key evidence without further authentication, and the entire case raises serious questions about whether this is legitimate justice or political persecution. Justice requires evidence that meets basic standards of reliability, authenticity, and legality. Justice requires transparent proceedings where the public can see that proper procedures are being followed. Justice requires that even the most serious charges be proven beyond reasonable doubt with credible evidence. Based on what we are seeing so far, this investigation falls far short of those standards. The lack of corroborating evidence, the constitutional violations, the chain of custody problem, and the jurisdictional issues, the closed proceedings, and the political context all point to a deeply flawed process. The judge's decision to require the forensics expert to testify before admitting digital evidence is encouraging. It shows some commitment to proper procedure, but it also underscores how weak the prosecution's case is at this point. If South Sudan wants to build a credible justice system, it needs to ensure that even the most serious cases are prosecuted with rigorous evidence, respect for constitutional rights, transparency, proceeding that the public can trust, and adherence to the rule of law. Right now, this case doesn't meet those standards. The trial will continue, and we will be watching to see if the forensics expert finally appears to authenticate the digital evidence, and whether the prosecution can present more substantial proof connecting the defendant to the attack. So, what do you think? Does this investigation inspire confidence in South Sudan justice system, or do you see the same red flag as I do? Let me know in the comment below. If you found this analysis helpful, please like the video, subscribe to the channel, and hit that notification bell so you don't miss future coverage of this trial. Thanks for watching, and I'll see you in the next one.